All right, I'm William Moore. We're back. I'm here with Drew Atria, the 30-year veteran public defender in and for Broward County, Florida. Drew, I want to talk to you about identifying leaders on a presumptive panel, why it's so important, and how you do it. I know you've done so much research right down to the kind of shoes someone's wearing.
True.
And personally, I think that identifying leaders is so important because if they're going to vote against you, you want to know so you can balance them. And if they're going to vote for you, you want to make sure that you do what you can to keep them on, especially if they're down the line in jury selection, because they aren't going to be swayed and they're going to convince your jurors, even if they're the only one that wants to vote not guilty ultimately when it comes down to it. Persuade the other jurors as long as they're not leaders and they're not button heads. Tell us what you implement in order to identify the leaders and also not single them out and pick on them.
Okay. First of all, I never pick on them, and I don't think people should pick on them or give the impression. I think it should just be a conversation.
I think but what I mean by that is sometimes when everybody's nervous sitting there on the presumptive panel, just by asking them questions right off the bat and sort of focusing on them, some people love it, some people get a little put back by it.
Yeah, leaders won't. And by the time we get to go,
That's a
which
good
is
point.
third, they're probably sitting there at least for an hour approximately. The judge will do 30 minutes, the prosecutor will do 30, give or take. So they're there for about 40 to 60 minutes before they even get to talk. You get to talk to them. I found that rather than just guessing at who I thought they were based on their body language, the way they spoke, the way they sat, the things they wore, how they dressed, was why don't I just ask them who the leaders are and why they think they're leaders? And so I would do that. I would start out by telling them the first thing, that this is a case about, let's say, self-defense. And then I would say, we're going to talk about that, but before we do, how many people here, by a show of hands, feel or think they're a leader? And once they would tell me, they put up their hand, I would ask why they felt or thought that way. And being a people person, I would already know what they had in their backgrounds, what they did for leisure activities, what they did for their work because of the questions with the prosecutor and the judge. And so I would go into one of those areas.
It's another great thing about being on the defense table is that you get to go last. And
even if you go second, the judge, they told the judge something. And you can tell a lot about people by what they do. One woman.
Have you ever had to go second right after the judge?
No, but I wouldn't have cared, actually. But the point is that if they tell you that, for example, they like gardening, one woman told me that. I said, did you think plants had feelings? And she said, yes. And I said, me too. And some guy laughed. I said, you're laughing? I think they have feelings too. So I basically defended her.
And became the hero, and now the jurors are identifying with you and loving you.
It sounded crazy, but I had read about it. Had just been research done on it, not me, but things I had read.
Now you had to get that guy off the panel, ultimately, most likely, if he was a bad sport about the whole thing.
He wasn't, and I did it in a nice way that made people laugh and feel comfortable. I just said, I think they have feelings too.
It's pretty cool.
At any rate, and all I want is a panel that will be honest about one question: if the case is not proven beyond a reasonable doubt, how would you vote if the state doesn't prove what they say happened? That's a pretty honest question, and I think people will be honest about that. And tell you that they vote. It wasn't because I tell them the verdict form doesn't say it says guilty or not guilty. What that means, proven guilty or not proven guilty.
Right, it doesn't say innocent.
Doesn't say innocent.
The state's got to meet the burden.
Right. So as long as I open them up to the idea, which sounded and is fair, I think I got fair answers. You know what I mean? Honest answers. But you had asked about how do I identify them. I would ask them who's a leader, and then I would say why. And no matter what they said, I would find a way to bond with it or agree with it, because we like people like us. So if I am you, as you are me, and we are all together, as John Lennon sang, then we're on the same level. We're cutting down the barriers. I never tell people I'm a lawyer. Of course, in court, they know that. I don't want a barrier between us. I want to say I'm just me, and if you like me, good. If you don't, that's fine too. So I try not to be a lawyer when I'm standing up there. I try to be one of them. And I think that works out well. I've read that when I'm reading their body language or their clothing, that people who are comfortable with themselves and which would then therefore be more open, wear loose or comfortable shoes.
See, now that's the thing. Generally, especially young lawyers are taught, can't judge a book by its cover, not to draw inferences when you see the panel walking in. And I'm not getting into stereotypes with demographics or minorities or anything like that, but just style of dress and whether or not somebody's kept, groomed as opposed to not groomed.
No,
But you sternly disagree with that. I mean, you've gotten pretty deep into this stuff and read a few books on
Right.
learning a lot about an individual just by the shoes that they wear in conjunction with some other things.
Books, articles, anything I can find. I'm
I have to agree
fascinated
with you.
Psychology. I'll give you an example. A person whose hair is groomed and slicked down and so forth versus a person whose hair may be a little looser or a little unkept. That person is a lot easier, more malleable, more amenable to reasonable issues. A person who is buttoned up tight to the top of their shirt versus a person who wears a comfortable shirt that's open and loose. The shoes, as I mentioned, their entire dress, everything we have about us. I read something when I was in my 20s that was something to call with your sweatshirt. Everything we wear, everything we do and say tells something about us.
Nonverbal communication.
Depending on whether you're astute enough or you know enough about it. And generally what it is, it's a first impression where you look, you see, and you feel. Trust it. Because it's like the book Malcolm Gladwell's Blink, thin slicing. Within seconds, we can gather as much information as we need, even if we took weeks. It's not going to change.
Fraction of a second.
Yeah.
Opinions are formed, which is what you always have said.
And they never change. A Princeton study was done and said that when 1/10 of a second, a first impression is formed. Other studies, 2, 3 seconds, 5 seconds, 7 seconds. But 1/10 of a second is how long it takes to blink an eye. I found that out. So think about that. And your impression never changes. You make all the new information fit that first impression.
So in the first impression, that's made in a fraction of a second. You get up to ask the questions of the jurors.
Mm-hmm.
Early on, first question, who thinks that they're a leader here?
Mm-hmm.
How many of y'all feel that you've got leadership qualities?
Mm-hmm.
Before they
why?
get comfortable. And why?
Because see, you haven't done anything in terms of, a lot of people will challenge their answers. Well, you would agree with me that you'd follow the law. What
Right.
are they going to say?
Automatic
I'm
responses.
not interested in that. All I want to do is find out who they are and see if we can relate to each other and see if they'll vote not proven guilty if it wasn't proven guilty. And so by asking them who thinks they're leaders, it doesn't have anything to do with anything else except themselves. It doesn't have anything to do with the case. And it tells me who's going to be the foreperson more than likely.
Right. And the cards are stacked in the defendant's favor, or the defense attorney's favor, in making argument or trying to win a case because the state's got this burden. And will they only have the burden? I mean, by law, they certainly have the burden to prove the case beyond it to the exclusion of any reasonable doubt, each and every element. But that's only if the jurors are going to follow the law. If you, as a defense attorney, have picked the right jurors that are going to apply the law, first and foremost, and understand reasonable doubt, which can be tricky for anybody to understand also.
But it's easy. And I'll tell you why I say that. Because it's a reason to doubt. That's what reasonable is. It's a reason. So if you had a reason that you didn't think it was proven, how would you vote? Not guilty. If you had a reason, there could be 7 reasons, there could be 1 reason. The point is that you can't be in a situation where you say, I'm not sure it was proven. Well, if you feel that way, what are you going to vote? So I think reasonable doubt people get worried about it, but I think if you break it down to simplicity and simple terms, do you have a reason? Are you sure? And I already know whether there's going to be a reason in there, more than likely. At least what I
Right, your
expect.
defense, yeah.
I start with the jury instructions and work backwards and find out what the state can't prove.
True.
And then I sell them that. And for example, let's say a person I know weighing the evidence, You don't have to believe any of the evidence. All of it, some of it, none of it. It's up to you. You're the triers of that. If the person's going to make different statements, or if I know they're quote unquote lying, I would ask them, well, you ever have a situation where somebody told you something and you knew it wasn't true? How'd you feel about that? They start thinking, oh, we're going to hear from somebody who's not telling the truth. You try to lay it between the lines of what you're expecting.
Prepare them. Yeah. The acceptable pre-trying of the case, because reasonable doubt can come from the evidence, lack of the evidence, or the conflict in the evidence. I think that's really one of the key things that you have to establish. It's easy to establish with the jurors, and then you hit it home in closing.
And I always use those, particularly weighing the evidence in jury instruction and reasonable doubt.
Sure.
You know. Oh, and another one I would use is the presumption of innocence, but I would switch it, because I found out that if I would just say to you, all American citizens are presumed, what did you hear in your head?
Innocent.
Yeah. So what I'll do is I'll say, you know, all American citizens are presumed guilty. And for sure, some of those people's heads are going to jerk.
Wakes them right up.
What's wrong with that, Mr. Moore? I just noticed you had a little... What do you mean they're presumed innocent? You don't believe that, do you? You do. Come on. Miss So-and-so, do you think that all American citizens are presumed? You do? Come on, you don't believe that. You've got to get them talking about the concepts, because their arguments are their arguments. Their arguments are the ones they're going to believe. Their beliefs are theirs. We can't make them believe something they don't believe. We shouldn't try.
You have been listening to the live stream of State of Arrest with criminal defense lawyers William R. Moore and Drew Atria. If you have questions for the show, call or text to 954-523-5333. You may also email the attorneys at wrdefense@gmail.com. Stay tuned, because there's more to come after this short break.
All right, we're back. Drew, we were talking about identifying leaders on your presumptive panel, and why that's so important. Number one, you're going to want to get rid of the leaders that you're sure are going to vote against you, have hidden biases, because the leaders are more apt to, when you agree, more apt to hide that from you in order to get in there and see what they believe is justice is being done.
I just want people that are going to apply the burden of proof. In other words, if the case wasn't proven, if they had a doubt that the case was proven guilty, what would they vote? I remember a couple times I would talk to people just in general, meeting them, talking with them, not asking any presumptions, questions, any burden of proof questions or anything like that. Just to get to know them and let them know me, because if we want people to reveal themselves, we must reveal parts of ourselves. So I did that, and then I started to sit down and actually thought of a Columbo move. And just before I sat, I was almost in the chair, I stood up and said, oh, by the way, is there anyone here, if the state didn't prove this case beyond a reasonable doubt, wouldn't vote not guilty? Of course, everybody went, no. And I was still starting to sit down. I go, I didn't think so. I sat down. Showed that I trusted them. That's the whole thing. If the case is proven, then vote for them guilty. If the state proves it, vote guilty. But if they don't, what are you going to vote?
Right.
Simple.
You say Columbo moment. It's like a eureka moment, right?
Yeah. No, well, I knew I was going to do that.
Oh, okay.
But I did it like a Columbo move. You know how Columbo, he'd be walking out the door, oh, wait, one more question. And that'd be the answer to everything.
Was that the one with the lollipop? No, it was. I don't know. It was the guy with the shaved head.
Oh, no, that was Kojak. Columbo was the guy, the rumpled guy in the raincoat.
I think I was watching Dukes of Hazzard back then.
Old car. Yeah, probably before your time.
Right. That's what
he seemed bumbling. He seemed like he didn't know what he was doing, but he was very bright, playing dumb. I wasn't.
One more question. Mm-hmm. Right? Or is it always the one more question?
Yeah. Almost like it's an afterthought as he was almost ready to leave. Oh, by the way. Oh, yeah, thanks. And he'd leave. And that would give him his case.
I hope it's only that easy on my tracking warrant issue. And one more thing, Judge, you signed this warrant.
You are listening to the State of Arrest with criminal defense lawyers William R. Moore and Drew Atria. If you have questions for the show, call or text to 954-523-5333. You may also email the attorneys at wrdefense@gmail.com. For more information on how to appear on the stream, contact us by email and be sure to include state of arrest in the reference field.
Do you use humor? Do you try to make the jurors laugh? Do you go out of your way to make them laugh?
Make them laugh. No.
You seize an opportunity when given one.
If it happens, it happens, but I don't try to make them laugh.
You got to succeed if you do that.
Well, I think it's a serious situation, so I don't want to inject any humor into it when I'm demonstrating the sincerity of it. I always took things seriously. I took this defense of a client seriously. So no, I didn't specifically. I don't really like it because I think it can fall flat so easily. It looks a little disingenuous sometimes and flippant. It's a very serious situation, and I want them to know that.
I think the only time that it wouldn't be disingenuous is if the theory of your defense includes the fact that we're wasting everybody's time here. This is a joke, and it adds to the air of confidence. But of course, the opportunity has to present itself. You can't going out of your way to make the jurors laugh as if you're some kind of comic is absolutely ridiculous, which I've seen on both sides. When I was a prosecutor, I saw defense attorneys do it, and I see prosecutors try and do it to this day, and I think they're in less of a position to be comical under any circumstances. I think it's got a place, but the opportunity has to present itself, and whether or not you've got a good, acceptable sense of humor, because you really do put yourself out on a limb doing that. You know, if you fall flat on your face, you don't just look like an idiot in front of a jury, and who knows what ramifications that would have. You get in some trouble with the judge, I'm sure.
Could be, and also, what does it do to the sincerity that you projected regarding your defense and your belief in the client's case, and the belief in the fact that this isn't going to be proven.
I could see it going both ways. I think you come across as being very sincere if you've got a lackadaisical view because your theory is that what a waste of time. Give me a break. We're going to win this. Jurors, you guys are going to see this too. Making light of it, I think it could come across as being very, very sincere, but you do take a risk. Oh, undoubtedly. But when you hit it, it's just perfect. It's just perfect. I want to ask you something before we wrap up. If I can get my hands on a prosecutorial notebook that they put out and give to all the prosecutors, a recent edition. Maybe we'll go through some of the standard stuff and pick it apart, like the hypotheticals that they tell prosecutors to use in voir dire and in questioning. All right. Drew, thanks again.
Thank you, Ryan.
All right. See you next time.
All right.
Thank you for listening to State of Arrest. Be sure to catch us next week, and remember that you can review portions of this stream on the YouTube Crime Celebrity channel. Please submit all questions to either William R. Moore at crime-lawyers.com or Drew Atria, criminal defense attorney in Fort Lauderdale, Florida.